cost. ADR also frees the judicial calendar as judges are left to deal with other pressing matters. The issues are dealt with in the public domain and become public further. ADR also allows parties to choose and agree on ways of resolving future disputes in advance. So who is involved in ADR? We may have top management team amongst themselves, the top management team versus the board, the organization versus the contractor, a large business against small businesses, a large business against a large business, a business versus a consumer, or an employer versus an employee, or at times, two or more individuals having disputes. They could be family members, they could be neighbors, they could be business partners. Now, let's zero in on the techniques, the ADR techniques. I'll be zeroing in or focusing on the four main ADR techniques. These: negotiation, mediation, conciliation, and arbitration. Of the above, you realize that conciliation and arbitration are provided for under the Labor Act, Chapter 23.01, whereas arbitration is also guided and informed under the Arbitration Act, Chapter 7.15. The first one, negotiation. First, ADR technique, negotiation. This is an attempt by the disputing parties to find each other without involving any third party. It is an informal technique where there are offers and counter-offers that they agree. This process is voluntary and may or may not resolve a dispute. Usually, it's just the more senior representatives of each side meeting up to negotiate. Negotiation is often the first option for those wishing to resolve a dispute by attempting to negotiate a compromise. If required, dispute resolution specialists can take instructions and negotiate on behalf of the parties. This form of ADR is often overlooked because of how obvious it is, because it's just a negotiation. There is no impartial third party in negotiating to assist the parties with their negotiation. So the parties must work together to reach an agreement. For example, salary disputes, where Section 82 allows for collective bargaining agreements between the employer and employees' representatives, who may be the employer associations or the trade unions. So you realize that on salary negotiation, on salary issues, disputes, negotiation come in handy. The benefits of this ADR technique are that it maintains good relationships, it's inexpensive, it's faster, because even in a day, you may even reach an agreement. It also allows for privacy. However, the flip side of it is that it's not legally binding. It can be used as a stalling tactic to delay issues, or there are no guarantees of resolution and no expert third-party opinion. That's it for negotiation. The second ADR technique is mediation. In mediation, this is done on voluntary basis and may be formal or informal. The mediator is chosen or selected by the disputing parties. It is a preference and a recommendation for people to work out their conflicts without relying on the courts for resolution, as has been noted earlier on. In mediation, there is no declaration regarding which party is right, and there is no placement of blame. Mediator's purpose is to guide the process and properly define the issues to remove the impediments that stand in the way of a resolution. Mediating parties are not put under oath and are not formally questioned. This is more like a conversation and not a courtroom session. It is confidential, and any admissions or statements made during the mediation process cannot be used against the party in a later court proceeding should mediation fail. Neither mediator nor disputing parties can divulge information in a later court. However, the resolution is not binding unless it then becomes a signed settlement agreement. A mediator is a jointly instructed neutral party. Their role is to assist in communicating between the two parties, having the dispute to achieve a settlement or resolution. The mediator will discuss the issues openly and try to help the parties reach an agreement, but will generally not offer his or her own assessment. In some cases, the court will insist that the parties will need to explore the mediation routes before bringing a case in front of a judge. Advantages of having this strategy are that the parties can jointly choose a mediator. It's less expensive and faster than litigation. A neutral third party can help parties reach a fair agreement. Also allows for privacy. It demonstrates a willingness to negotiate. However, it's not legally binding. An incompetent mediator can hinder a resolution. To be legally binding, the court enforcement is then required. More expensive than negotiation, and it can become expensive in the long run. The third ADR technique is conciliation. This is guided by the Labor Act, Chapter 828.01, and specifically Sections 93 to Section 1. This process is more formal than the previous. In some cases, it involves the appointment by parties of a person to attempt to resolve the issue. This person is usually professional and respected by the disputing parties. The process here is still informal somehow, but depending on location, some use or regard mediation as conciliation. However, in Zimbabwe, in the labor context, there is no mediation but conciliation, which is presided over by a labor officer. Conciliation is a more common form of ADR used for employment disputes. The conciliator will discuss the issues and try to help the parties reach an agreement, often providing their own opinion after assessing the situation and the different arguments. The conciliator is used to help parties recognize their position in the dispute and come to an agreement. If this takes place, then disputing parties move to arbitration. The benefits of this strategy are that, like the previous ones, or all the ones that we're talking about, that it maintains privacy, it's more cost-effective than taking the dispute to court. The conciliator is usually an expert in the disputed field. However, this strategy is not legally binding. No resolution is guaranteed. Parties may not take the process seriously. The fourth and final ADR technique we are going to be talking about is arbitration. I'm happy we've got an arbitrator by my side here. And I'll just talk about the general direction, and then he will talk about the actual direction. This is guided by the Arbitration Act, Chapter 7.15. This act looks into domestic and international disputes where parties to the dispute agree to be legally bound by it. It may have a binding effect or a non-binding effect. The binding arbitration is when parties waive their right to seek review of the arbitrator's decision as final. When it is non-binding, the parties are free to request a trial if they do not accept the arbitrator's decision. This technique is more common than any other so far discussed, yet less formal than litigation. A neutral third party called an arbitrator is often either a retired judge, or a professionally trained arbitrator, or an experienced attorney. An attorney may represent either of the disputing parties. There are opportunities to ask questions and decisions are written down. In Zimbabwe's industry and commerce, parties usually refer their cases to either to the Commercial Arbitration Center in Harare, where the chairperson of the Commercial Arbitration Center then sees it and chooses an arbitrator for the parties, or they can send it to the African Institute of Mediation and Arbitration. A case is presented, then an arbitrator makes a determination as to Arbitration Act, Chapter 7.1. Like we said, the decision is binding often. The arbitrator usually has relevant skills that are also specific, e.g., on issues to do with accounting or figures. A chartered accountant may be selected to become the arbitrator, or on matters of construction and design, a civil engineer may be selected to be the arbitrator. Arbitration is participatory, and a review may be allowed on grounds of public policy or procedural grounds to the High Court. The benefits of such a technique are that it is stronger, there is stronger enforceability than the previous techniques. Confidentiality is also part of the process. It's cheaper than litigation. It's more flexible than litigation. Reviews are allowable if one feels they need them. The challenges to arbitration include that the parties bear the cost. One, of the arbitrator, as well as maybe the venue. Also, the arbitrator may have limited powers in situations where if one party fails to adhere to the directions and rules set out. In conclusion, this presentation has highlighted the available ADR options in the Zimbabwean context and how they proceed and how they relate. These options is highlighted are negotiation, mediation, conciliation, and lastly, arbitration. I hope I was relevant. Thank you very much for listening. Asante sana.
Thank you very much, Leon. And I think I also then just forgot to read your bio, which I feel like I need to read. So you are a holder of Master of Commerce in Strategic Management in Corporate Governance, and you're currently completing a Master of Science in Development Studies. You have 5 years of experience at management level in the world of industry and commerce, 13 years of experience in development work with much focus and emphasis on children, youth, and women, and 3 years experience as a university assistant lecturer. You're actively involved in humanitarian projects, personal and professional development consultancy, whilst providing individual and collective counseling and coaching. Strategic lenses with a systems thinking approach in mind. You're a team builder, player, and believer. So once again, thank you very much, Leon, for the presentation. Thank you so much. Are there any questions? Feel free to ask your questions. You can just put them in the chat box and then we can attend to them. I think maybe one of the questions that I might ask here is, how do you navigate confidentiality within a mediation or arbitration process, or generally just an ADR process? How do you deal with the issue of confidentiality? Let's feel free to ask questions, guys. Just type them in and put them in the chat box and then we can ask. I think that's the first question.
Can I ask a question?
Yes.
Mediation varies from one industry to the other, I think. I just want to be able to talk a little bit more about the differences between mediation and conciliation. Because coming from our United Kingdom, conciliation obviously is very heavily to do with disputes in the labour sector. And there's even an organisation called CCAS, conciliation. I just wondered if Leon could just a little bit about the differences between mediation and conciliation. Okay.
Okay. All right. Okay. Is there another one?
There was someone
raising their hand.
Yes.
All right, okay. Yeah, you can.
Ms. Moyo, you can ask your question.
All right. Thank you very much for your presentation, Leon. My question was going to be, in what circumstances can the decision of an arbitrator be challenged? Because I know you mentioned that the advantage with arbitration is that it preserves the relationship between disputing parties. And with the court system, if parties are dissatisfied with the judgment of the judicial officer, there are opportunities for appeals to be made against the judgment up to the Supreme Court. So let's say, like, if the matter has started in the High Court, then to the Supreme Court. But with regards to arbitration, where the decision is supposed to be final, what remedies do the parties have if they are dissatisfied with the judgment? Is there any grounds on which the decision of the arbitrator can be reviewed?
All right.
Okay, so thank you very much for the questions. I think we'll attend to those.
All right, thank you. The first question was on ensuring confidentiality, as I was asked by Rutendo here. I think for us to agree on confidentiality and to safeguard it, we need to agree on it, and at times we have to sign down that whatever is going to be discussed here, it is going to, what happens in Vegas stays in Vegas, something like that. Yes. Second question was on the differences between mediation and conciliation. Like we said in the labor courts in Zimbabwe, like generally, like what I said, it depends with the areas. Some seem to see it as if they're interchangeable, but in Zimbabwean context, in the labor context, like I said, there is only conciliation rather than mediation. Any other areas, I think I may need to read further and try to find the difference between the two. But in Zimbabwe, like the labor acts, which I have cited, there is only the conciliation. There is no mediation. The third question was on the circumstances of challenging arbitration. From the presentation, I talked about they may be allowed on grounds of public policy or procedural grounds. But however, I cannot talk about a storm when there is a Noah in the audience. So I think my partner here will help me respond to that.
Shall I? Oh, Sarah, thanks. It's a good question. In Zimbabwe, arbitration is regulated by the 1996 Arbitration Act, which is, I think, one of the best acts in Africa, if not on the planet. And there are very tight, strict conditions in which you can either challenge an arbitrator or challenge the arbitrator's award. So in effect, the Act is the Bible. Okay, New Old Testament and New Testament as well. So very briefly, an arbitrator can be challenged on grounds of impartiality, Article 12. So if one of the parties believes that the arbitrator is impartial, that is grounds to challenge the arbitrator. The second ground would be a jurisdiction. Has the arbitrator got jurisdiction to actually hold an arbitration? Basically, that means either an arbitration agreement or an arbitration clause in the contract between the parties. Public policy is a difficult one. Most lawyers take arbitrators' awards to the High Court on grounds of public policy. It's happened to me twice, but luckily the courts looked after me and looked after my award. And it happened to me again last week, where the challenges on public policy. That's a difficult one to, that's a whole topic on its own, because it also brings in the rates, the US dollar rate and the Zimbabwe dollar. So that's another one. The other one is obviously, the most important one is the rules of natural justice. Now, which as a lawyer, you'll know what they are. So if an arbitrator fails to uphold the rules of natural justice, the arbitrator can be removed or the award will be set aside. Another area where you can challenge an arbitrator's award if it's incomplete. So if the arbitrator has failed to go through all the issues, and that's a difficult one too. I've got an arbitration where there are loads and loads of issues, and you have to deal with every single one. And if you don't, you can be asked by the High Court to go back and deal with them. Thank you.
All right, thank you so much, James, for the response. I think we will move on with our program. And right now, I think our next speaker is Mr. James McComish. And he's originally from Northern Ireland and educated in London at South Bank University and King's College. He worked there as a young architect with CPH architects David Rosenmount, Stuart Parsi, and finally with James Cubitt and partners until 1991, when he took up a contract invitation in Zimbabwe from Paul Castle, one of the partners at CPH. He has lived in Zimbabwe since, meeting with challenges and rewards of construction project development and regionally and in West Africa. This continent, at once magnificent, interesting, and complicated, has become the home he has enjoyed with his wife and daughter. So over to you, Mr. James.
Well, thank you very much, everybody. Thanks for inviting me. Arbitration is a love of mine. A little background, I'm a fellow of the Association of Arbitrators in South Africa. I'm also an associate member of the Chartered Institute of Arbitrators in London. and I'm also the current chairman of the Architects Council in Zimbabwe. In the construction sector, ADR basically involves three methods: mediation, adjudication, and arbitration. Before I talk about that, avoiding disputes needs to be ventilated. I'm a great believer of preventative maintenance. When you change a light bulb, you get rid of a tungsten, you put an LED in. So the idea, before we get to arbitration, is to try and avoid arbitrations. There's a great little book, tiny little book by an architect in London called Bart Kavanagh, called Avoiding and Resolving Disputes. I just want to quote from that. What causes disputes? According to the Global Construction Disputes Report in 2015, there are 4 areas where cause disputes. Number 1, failure to properly administer the contract. So I'm talking about construction now, not labor or IT or insurance. This is failure to administer the building contract. Number 2, the employer, contractor, subcontractor, failing to understand or comply with his contractual obligations. This is important because at the moment, Zimbabwe is going through a period where more and more work is coming from South Africa and abroad. They're bringing in their own contracts, building contracts, which we don't use. We're not familiar with them. Now, I cannot force a client to say, use a Zimbabwe contract. I want to use a Zimbabwe contract, use it. The money comes from South Africa. I need to use the South African contract. So we need to study South African contract. We need to know what our obligations are. Okay? Number 3, conflicting party interests. That's basically where subcontractors, contractors, employers have different interests. Okay? And then number 4, which is another one, incomplete design information or employer requirements. So basically, you get to site too early. You haven't completed either the design or you haven't completed the information and you're catching up. That will lead to disputes. So in my experience, very briefly, to avoid disputes, you have to have a hands-on day-to-day management approach of building contracts. So if you see an issue, you nip it in the bud very early on in terms of money or in terms of misunderstandings. If you leave an issue, it becomes an argument, and then the argument becomes a dispute, and then everyone's forgotten about what actually happened. You know, so the very early day-to-day contract administration by the architect or engineer will help you avoid disputes. Okay, so let's get into, okay, a dispute has happened. It's too late. You've been asked to sort of dispute. So what the parties do in construction is they use mediation. Okay, now mediation, quoting from another book by Stan Siegel, The Building Contractors of Africa. Mediation is similar to arbitration to the extent that the parties voluntarily choose it as an alternative means of resolving their disputes, and they choose a neutral third party to hear the dispute and advise them in reaching a settlement. So basically, what happens in construction, myself, I'm called in to mediate. The dispute hasn't happened yet, but there's a difference, and it could be a dispute. If you're called in to mediate, it's private. Okay, it's non-binding, like Leon says, but I'm in an arbitration at the moment where the parties tried mediation and it failed, but it helped the arbitration because they've actually resolved some of the disputes. So I recommend mediation. It's private, they can choose whoever they like. It's normally the architect or the engineer, or they can take a QS or anybody else. So they choose a mediator. If it breaks down, no harm done, you've tried. You brought the parties together to sort of dispute, because with mediation, there's a business relationship. You want to keep that relationship going, and maybe future business relationships. It is non-binding, so if it fails, you move on to the next step. Now, on construction contracts, the building contract in the United Kingdom called the JBCC 2005. That's a great building contract. It's got mediation in there, so it forces you to mediate first. Okay, no other building contract has got this. In fact, this contract has got all 3. Dispute resolution, it's got mediation, adjudication, and arbitration in here. No other contract's got that. Our Zimbabwe contract has only got arbitration, but The JBCC building contract in South Africa has got a very good arbitration agreement. By the way, in a building contract, the arbitration clause is called an agreement. You have an agreement to arbitrate. It's not just a clause, it's actually a physical agreement. Now, so I've talked about mediation. Yeah. The other thing I like to talk about is a lot of clients start construction projects without enough money to finish the job. That's an arbitration right there. That's a dispute right there. And sometimes my clients don't like it. I say, listen, you have enough money to finish the job. Please don't start with it, because if you look over Harare, there's loads of construction sites that take 5 to 10 years. That's a dispute right there waiting to happen. So please, I say to my clients respectively, please ensure you have enough cash flow to finish the job. If you do not start, or we do it in phases. We build one floor or one block other than the whole lot. That will avoid disputes. So cash flow is very, very important. Now, mediation, I'm going to move on to a new, another dispute resolution in the construction industry called adjudication. In the United Kingdom, it started in the late 80s, and then in the 90s, and now it's been legislated. So you have a formal method of adjudication. And adjudication is more formal than mediation, but it's a fast track, cheaper version of arbitration. Again, I'm quoting from Stan Siegel's book, The Adjudication Process. Adjudication is an accelerated form of dispute resolution in which a neutral person determines the dispute as an expert and not as an arbitrator, and whose determination is binding on the parties unless it's varied or overturned by an arbitration award. So adjudication started in the United Kingdom, it's now in South Africa. And this is the South African building contract, the ZNCC, edition 6.2. In here, they've been very, very cheeky. Okay, what they've done is, if you go to adjudication, you've only got 10 days. The adjudicator has got 2 weeks, that's it. And there's no lawyers. And that's going to upset you, Sarah, but there's no lawyers. You're not allowed a lawyer. Okay, the idea is this adjudication, a third party comes in, we've only got 10 days, and guess what? No meetings. It's all on the papers. What they found out in the United Kingdom is if you start having meetings, it slows everything down. And God bless the lawyers, you bring in lawyers, it actually can slow things. So I don't want to upset the lawyers here. But so adjudication is a very rapid way of bringing the dispute to it. In 2 weeks, there's a Zimbabwe contract, building contract, another one called the NJPC 2000. Adjudication is in here as well. Here's a bit longer. Here's 10 days as well. You want to get 10 days, and there's no meetings. The parties are urged to submit your papers only. So that's basically adjudication. And if adjudication, one party doesn't like the adjudication, then you go off to arbitration. Now, arbitration is at the moment the most common form of dispute resolution that we have in Zimbabwe. The great thing about arbitration is the Act. The Act was written by Mitchell Sunda, Ian Donovan, and Tony Mackay. And it's one of the most respected forms of legislation we've ever come across. It's also recognized as the ownership trial, international arbitration agreements as well. And how arbitration works is that there's an agreement in the building contract. One party is not happy, either party, it's normally the party owed the money. They invoke the arbitration agreement. The standard arbitration agreement has, if the parties fail to agree, first price is the parties agree on the arbitrator. They never do. They never did. Everybody wants someone to help them. So then an independent body is written in the arbitration agreement. The building contracts in Zimbabwe states that either the chairman of the Architects Council, the president of the Institute of Architects, or the Commercial Arbitration Center. Okay, and they choose the architect. Sorry, the arbitrator. Now, how the arbitration works is that we so the arbitrator is appointed. Both parties have to agree that appointment. After that, the arbitrator then gets the arbitration alive. So the arbitration is alive, and the arbitrator has a meeting called the principal, called the preliminary meeting. At that meeting, the parties that are hopefully with their lawyers. This is when the lawyers have a valuable role in arbitration. They guide the clients and the contractors. They don't know how to do a statement of claim. So the lawyers produce a statement of claim. The respondent produces a statement of response, and then the arbitrator. Then, what my personal view is, I have many hearings. So I have the papers. I give the parties an opportunity to orally present their case, so I can tell if they're lying or not, as they're telling the truth. Okay. Then we have a series of meetings. The arbitrator goes off, spends some time, looks at the issues. If there's any problems with the issues, the arbitrator can ask, but the arbitrator cannot enter the fray. This is very important. The arbitrator can only make an award on what the parties bring forward to him or her. If a party makes a mistake, or if a party says something wrong, it's not the arbitrator's job to help either of the parties. The arbitrator is there to listen. If something is confusing, the arbitrator will ask for that point to be cleared. But the arbitrator will not cite cases, for instance. I don't believe arbitrators should. I have to listen to the parties. And I will will listen to every single issue that they bring forward. And an arbitrator will make an award on every single issue. Two types of awards. One is an unreasoned award, one is a reason. An unreasoned award is wrong in my view. The arbitrator has a duty to tell the parties why he made that award and give reasons. Okay. And these days, most awards are being challenged in the High Court. They're going off the High Court because one party, there's a substantial sum of money they don't want to pay. So they can delay the arbitration by months. Another good thing about arbitration is you pick the person for the dispute. So this construction, you can pick an architect, quantity surveyor, or an engineer. If it's insurance, you can pick an insurance. If it's a legal matter, you can pick a lawyer. If it's IT, you can pick somebody with IT experience. So the arbitrator knows the industry in which the dispute has arisen. Arbitrations are fairly quick if you handle it rightly. We do call expert witnesses, but a better way is to call as the expert witness statements. They issue statements so I can read the statements. But I feel that the statement is inadequate. I can either party can ask for an expert to come to what I call a mini hearing. And in a nutshell, that is how arbitration works. The judges at the moment in the High Court and Supreme Court respect the Arbitration Act and they respect arbitrators, but they will not tolerate abuse by any of the parties, but they will set aside an award if the award is defective. One point to note, if it's defective in law, I don't think the courts will enter that, but if it's defective in other ways, such as partiality or in terms of public policy, it can be satisfied. Thank you very much.
Thank you very much, James. We have any questions of that? We don't have. Is there anyone with questions that they would like to ask? Whilst we wait for the next speaker. I think maybe one question I might have is, how do you deal with foreign disputes? Let's say if it's a foreign company that wants to enter, that enters into a contract with the Zimbabwe construction company. Generally, how do you deal with those type of disputes?
First of all, the dispute for an arbitrator to hear dispute, the dispute must, the work of the contract must have taken place in Zimbabwe. Okay. And I don't do international arbitrations. I'm just too busy. to do that. So it's for the we only handle disputes. So if a dispute is a cause of a football, we can't deal with it. But it's a valid point. So the dispute for the arbitration to be alive, the contract needs to happen. The work needs to be carried out in Zimbabwe, and the law of Zimbabwe will apply. So I can't have an arbitration here and use legislation based from outside Zimbabwe. I know it sounds like that's
All right, thank you. Yes.
James, so what about if somebody, one of the parties fails to adhere to the agreement, or else like your determination, what will happen?
okay. That's beginning to happen a lot. A lot of the parties don't want to do arbitration. They just don't want to pay the money. Okay, they know they're going to lose, so they say, "What? Why?" So they really drag their feet. And what I do, you've got to be robust. You've got to be robust, and what you've got to do is to make sure the arbitration agreement is valid. Make sure you have jurisdiction, and then what I do is I have a preliminary meeting. If they don't come to the meeting, I said, fine, not a problem. That's the last bite of the apple you get. The arbitration will continue with or without you. So unless there's a tsunami, a car crash, or you've been arrested, if you fail to come to the next meeting, I will proceed, but I will give them a chance. Because I've had that before, Leon, where parties are really belligerent, are really awkward, and they feel I warn them, but I give them one chance. Because it's very difficult to, and it normally works, they normally come, because you can't publish a word in absentia, but it's you're asking a lot of a judge to back you up, because it will be taken. You gotta be firm, just but firm.
All right, is there any other question? No. All right, okay, thank you very much. I'm sure if there's other questions, we'll just take the end of the program. So moving on next, our next segment is ADR in the energy sector. And today we have Mr. Arnold Z. Chikaje. He's the co-founder and executive director of the Alternative Dispute Solutions Center. He specializes in global energy, international arbitration and environmental law at the University of Texas at Austin, Texas, USA, and is admitted to practice law in Zimbabwe. Arnold's arbitration experience includes representing clients at the Commercial Arbitration Center in Harare and conducting pre-arbitration advice and preparatory work under the China International Economic and Trade Arbitration Commission in Shanghai. Mr. Chikaje is also a professional educator and has conducted trainings for the Law Society of Zimbabwe, Zimbabwe Environmental Law Association, and Zimbabwe Energy Council, among other forums. He has also written articles and opinions by invitation for various forums, including the International Bar Association, All China Lawyers Association, Zimbabwe Energy Regulatory Authority, Zimbabwe Energy Council, and World Bank Group. Arnold is currently a legal manager and acting company secretary for Lafarge Cement Zimbabwe Limited, a member of the Holcim Group, a Swiss multinational company that manufactures building materials. So thank you for joining us, Mr. Chikaje, and we'll hand over to you.
All right, thank you very much. Can you please confirm that you can hear me?
Loud and
Yes,
clear.
yes, we can.
All right, thank you very much. It's my pleasure to be here and to make this presentation before you. And I'm sorry that I was late. There's an urgent issue that came out that I was dealing with at the criminal court. And then when I was coming here, apparently there was an internet blackout for some time here in Harare. I think everyone was affected. And that's when I was now trying to put the address in so GPS can accompany me here. But joyfully, I think the network just came back in the last 10 minutes or so when I was roaming around this area trying to find out where to go. But I'm very glad to be here. Unfortunately, I missed what the other speakers spoke about because my my plan was to make sure that at least I can be able to do my presentation in the context of what the other speakers would have spoken about, especially so that I do not have to repeat things that they would already spoken about. But in any case, I just prepared something that is brief because I was expecting that by the time that I will make my presentation, most of the foundational and general aspects of ADR would have already been dealt with, and that would then leave me to focus on maybe other additional areas and some key areas that I might suggest for those who are in the energy sector or who are in sectors that are related to energy. So my outline is that I'm going to talk about some of the advantages of ADR, and I'm not going to give exhaustive approach on this, but I'll just highlight on a few things that probably relate more to energy, but with an assumption that most of the things have already been spoken about. And I'll talk about a bit about key stages in ADR, but as I said, I'll not be going deep into those. We'll just highlight a few things. I'll talk about early neutral evaluation, which I think is something that people have not been doing, and I think it's something that we can start encouraging here in Zimbabwe also. I'll put some pointers about arbitration clause relating to energy, and I'll talk a bit about power purchase agreements just for 1 minute, in case that we have some people who just need to understand was an arbitration clause in the energy sector. Mostly is going to be found in the power purchase agreement, and then I'll also talk about other determinations. Okay, next slide, please. So the first thing that I will talk about in terms of advantages of ADR is the issue of committee. Having been written a lot of contracts and done a lot of contract management, whether it's energy, projects, and other things, I think if you look at ADR should not just be a clause in the contract where you say, oh, does this contract have an arbitration clause? Does it have a mediation clause? Does it talk about alternative dispute resolution in a specific clause? I think for someone who does contract drafting, and also even someone out there in the industry that is going to hire a lawyer to do their contract drafting, you can actually have a contract where all the clauses in the contract are written in a way that shows that you actually want committee to be something that goes throughout the four corners of all the pages in the contract. There are some contracts when you look at them, you'll be like, this looks like it's been written in criminal law, like criminal language, Then you look at other contracts, like, so this looks like it's very informal, and these people even split down. But I think when we draft our contracts, when we do our negotiations, we can frame our contract in a friendly language where in each clause of the contract, you are actually promoting that friendly atmosphere, not just focusing at the dispute resolution clause, but also even the entire contract. For example, if you are talking about the termination of the contract, you can frame this in a way that is going to promote a friendly way of dealing with termination, for example. And those are some of the things that I shall be adding, which we can actually be even outside the scope of the dispute resolution clause itself. And obviously, there's the issue of confidentiality. I think I'll point this out because we are all aware that we have seen certain contracts in the energy sector in Zimbabwe that have been blown out of proportion in press and media, where now people are now fighting and press, everything is coming to press. And the bad thing about that is that the public are not even going to have an appreciation of what exactly are the key elements of that contract. Because mostly when people report on these issues, they only choose things that are due to what the public wants to know. For example, what is the amount in the contract? What is the breach? But they will not even look at what are the fine underlying terms of conditions. So it's best for us when you have very huge projects, that especially projects of national interest, or that those we use arbitration on those ones, so that if something happens, then you will not end up having your issue going to court and then the press will pick up on it. And then you end up, instead of doing a business decision concerning that dispute, you end up having a political decision being made in that contract. Next, please. All right, so some of I'm sure that you have already been advised of what kind of dispute resolution stages that you go through and things like that. But as for the energy sector, one thing that I advise is that you should have a clause for notice of dispute. And the notice of dispute clause does not have to limit itself to the annual dispute resolution clause, but it can be in various clauses. For example, when I'm talking about the clauses for tariffs, clauses for capacity of the energy capacity itself, clauses for the availability of energy, clauses for the use of water, clauses for the use of roads, transportation, things like that. So you can have a notice of dispute. Those clauses can be followed. Excuse me, please. Let me introduce this. I'm sorry about that. I was just coming. What? All right. So the advantage of having notice of dispute is that when there's a dispute, the person that is claiming that there's a dispute has to now be able to write down exactly what are the details of the dispute. For example, what I've seen being in industry where I'm counsel, internal counsel for Lafarge, for example, when you have technical disputes, I've seen that lawyers tend to shy away from technical disputes. Sorry about that. I'm trying to put this on silent and I'm struggling. These phones are very smarter than us. Okay. So, like for example, whenever there's a dispute that involves a technical nature, that is of technical nature, then I'll ask the engineer, say, guys, can you please prepare a technical report concerning this issue that has happened, so that we now start exchanging a technical report with the other party. We give them our technical report, then they give us that technical report, so that we can be able to understand what the issues are, who is to blame for whatever would have happened. But we find out that most of the times, the lawyers don't have the patience to allow even their clients to prepare those technical reports and exchange technical reports, so that they can be able to deal with issues amicably. But I would advise those in the industry that these are very important issues, because you end up not wasting time now going into arbitration, for example, where you could have been able to settle something, where you could have been able to exchange technical reports, and then the other side would have been able to see that, oh, scientifically, this is the problem that we've encountered. So when you look at the energy sector, for example, it is a very technical sector where, for example, you can bring something to court and the judge may not even be able to understand what you're talking about, because this can be a very technical, it can be a very technical issue. For example, if you are talking about a need of power, and then I say, no, I'm not receiving enough power. Why is that? Then someone will say, we did set the panels the correct way, they are facing the right direction, the angles are correct, everything is correct. But then someone say, no, there's some dust on that has been on those panels. That's the reason why the panels are not operating. So those are things that someone would put in the technical report to say, okay, if you think that the reason why there's no performance because there's dust on the panel, then bring me a technical report that shows what are the effects of dust on the panel that can be stored. Then someone can now be able to say, okay, so this is not your fault. The fault is that there's dust on the panel. What's the solution? Let's get them cleaned professionally. Then also what you also want to do on the notice of dispute is make sure that parties can be able to continue with performance even if there's a dispute. Because sometimes you have a problem where there's a dispute, then one party stops performing. But now let's talk about the energy industry, for example. We are providing electricity for homes. And then there's a dispute, then people's lights get switched off. Is that an outcome that anyone would want? No, you don't want to have such an outcome. because you now will end up having a situation where you are going to now perform under duress because there's been an interruption of power, and now there are other stakeholders who are now involved in the dispute, which should not have been involved in the first place, but their interest now just because I don't have power in my office, I don't have power at home, I don't have power in the hospital, so they now become part of the dispute. But if you have included in your contract that, for example, even if there's a dispute, there should be continued, or the performance must continue, then that will actually help you be able to solve this dispute amicably. Because when you talk about ADR, we are talking about an amicable way or an alternative way of solving disputes, where you are solving a dispute with someone that you are doing business with. So you don't want to interrupt that business. Then the other thing is early mutual evaluation. I think that's something that we need to start promoting in Zimbabwe. Like what I was talking about, let's say you've got two parties, you've had your technical report, the other party has had their technical report, but your engineers, they failed to find a common ground, to say, so who is to blame, how do you go forward? Then you can actually have a third party who can be able to now look at these two technical reports and be able to advise you and say, you know what, if you go for arbitration, this is the likely outcome. If you go to court, this is the likely outcome. So this is also another method that we can start using, which can help us to resolve issues amicably in the sector. Then, as far as arbitration agreement is concerned, I know that you've already spoken about it, so I'm just going to highlight some of the clauses that you can be able to include if you are in the energy sector. For example, if you know that this is a dispute that is of a technical nature, then you can also have one of the arbitrators, three arbitrators, you can have one of them who is someone who has got experience in the power sector. Or you can have the other two, who don't have experience, but the umpire who have experience with the power sector. Then also because energy projects are very capital intensive, they usually have a financing party, which will invested sometimes hundreds of millions of dollars, even billions of dollars. So you also want to have dispute resolution where the financing party can also be joined in into the arbitration. Because, for example, you can have a dispute now where one of the parties will say, I'm no longer going to perform until this dispute is resolved. But the financing party say, no, I'm also meant to be getting this amount of money every month. So if you guys now are going to have a dispute concerning the use of roads, concerning transmission, this is for transmission, I should not be affected. So you have to at least have a way where the financing party can have its rights protected, even while the other parties, the buyer and the seller, are being involved in a dispute resolution. They can resolve their dispute maybe for the next 6 months, but at the same time, the financing party will not be prejudiced. So this is something that you may want to include in your agreement. Then this is just for those who do not know what the power purchase agreement is. If you're generating power, we have what we call a bankable power project. A bankable power project means a project that is profitable. When you bring your proposal to a bank, when you bring your proposal to a financing party, they can actually be saying, you know what, I can put my money on this. So that's what a bankable power project is. And usually it has to have a comprehensive power purchase agreement, which shows that it has got off-takers who can purchase the electricity, and there's a grid connection that can be able to deliver the electricity to the end user, and they have to be competitive tariffs both to the user and also to the financing party to make sure that it can finance the project. And obviously, you want to make sure there is a fair chance to make a return on the investment, and that will be both for the developer and also the financing party. And these agreements have to be enforceable and negotiated before anything starts. So I would say the power purchase agreement is actually the most important agreement when you are to finance a renewable energy project. Then other things that you can actually determine to allow that committee that I was talking about, that's the amicableness, You can also talk about the exclusion of consequential damages. And I've seen being in industry now, that the issue of financial challenges is probably one of the worst things that can ever happen to a company, because you can have a claim maybe that is supposed to be $10,000 US, but it can end up being uncontrollable now because you've just, for example, you failed to deliver electricity for 1 day. Then you can't have like now 1,000 bushers saying that the meat won't bad, so we want you to pay for it. Then it means that your damages that you have can now be, can be, for a potentially infinite value. So you need to make sure that there's an exclusion of loss of profits or loss to customers when you're doing an energy project. Then the step-in rights and costs. Remember, we're talking about the interest of the financing party. This step-in right allow, for example, if there's a dispute and the other parties they cannot agree, they are now prejudicing the project. The financing party can now say, you know what, I'm going to come in within those 6 months that you're having a dispute. I'm the one who's going to be in charge of running the project until you guys have finished your dispute, so that at least I'll make sure that this project will remain profitable. And this step-in rights and costs need to be accompanied by step-in cost that the financing party will then charge after the dispute has been resolved. So that's something that you can also. Then one thing that I always put in contracts is a duty to negotiate. So that without before you do any termination or any big decision that will change significantly your performance on a contract, there has to be a duty to negotiate that is entrenched in the contract itself. Then the other thing that can also help for you to now your alternative dispute resolution to work effectively is that in the first place, when you do your allocation of risk, you have to make sure that the risk is being properly allocated to the party that is best suited to manage that risk. For example, if there's a party that is going to be on the ground, obviously that is the party that is going to manage certain risks such as floods and things like that that actually happen on the location. And if there's a party that is more of a financing party, obviously they can be able to manage the risk such as monetary policy, fiscal policy, exchange rates and things like that. That's a risk that can be managed by the party that is more of a financing party. Then the issue of assistance is where parties now have to assist each other when certain things are required. For example, you might have a buyer. For example, let's say I'm selling to the government, and I'm a very small party. Then I expect that the government will help me with certain payments. If I'm having a problem getting a payment, then my buyer, which the government should be able, obviously, to help me to navigate through the government offices to know who is the person that has to help me with the payments, the licenses, importations, and things like that. So then the accommodation of lenders is the same thing as what I was talking about, the financing party. The lenders, there has to be a way where if there is a problem, the lenders can also be able to help out and have these disputes resolved in a way that is beneficial to the project. Then the last thing I'm going to talk about is good faith and fair dealing. The whole contract itself has to be a contract that is conducted in the spirit of good faith and fair dealing. It has to run through the whole contract. That will be my presentation. Thank you.
All right, thank you very much, Mr. Chikache, for the presentation. I think I have 3 questions. I'm not sure if there's anyone else who has questions in the chat. Oh, you've also got a question, that's fine. Okay, there's no questions at the moment. All right, okay, fine, that's fine.
There's no question.
So yeah, maybe you can ask your question first.
I'm just interested about this consequential damages. I mean, what happens if there's a cloudy day and there's no sun? So consequential damages. I mean, surely, I mean, what happens? You've got your power purchase agreement.
Yes.
You're selling power, but it's a cloudy day. There's no power.
Sorry, people are leaving. Sorry, I couldn't change the book. Sorry.
No.
I don't know.
No, it's just interested, I know that, you know, sunlight's unreliable. So your power source is unreliable.
Yes, yes,
I mean, I know Zaz is as well.
yes, yes.
But this is unreliable, so you can't guarantee somebody using power.
Mhm.
So that's, you know, like, there can't be any discussion, I think, of consequential damages.
Mhm.
Because it's not like your manufacturing part, you're totally reliable on the weather.
Mhm.
Your whole contract
Mhm.
is reliable on as well as depends on a unreliable
Mhm.
weather.
Okay.
So you know, when you enter into a contract like that, the weather's not in your control.
Mhm.
So, you know, no one can really expect consequential damages for a power generation that depends on the weather.
Yeah, I would say I would agree with you. Depending on exactly what kind of agreement you are entering into. But like right now, because of what has been going on with the CESA, we are now having companies that say big companies in Zimbabwe have now formed a consortium where they can actually be able to import reliable power from outside Zimbabwe. So you now have a contract for power that is guaranteed. I'll give you an example. We import power from Zimbabwe, from South Africa. Our contract with South Africa is such that there's a minimum amount of power that Zimbabwe has to get from South Africa, even if South Africa cannot fulfill its own domestic needs. Similarly, I believe we've got an agreement with Namibia. I need to check that, where they financed one of our power projects. And we have to guarantee them a certain amount of megawatts, no matter what, even if Zimbabwe doesn't have power. So there are such contracts where you are what you have is the capacity contract, where there's a delegated amount that has to be delivered almost no matter what. And if it's not, then it has to be considered maybe there's a natural disaster, force majeure events, maybe will be the only thing to excuse that. But I understand where you're coming from, and I do agree as far as more projects are concerned. But now, when you look at the movement that is going on now in power, we are looking at most industries are now looking at power that is guaranteed. For example, at Lafarge, we've got a new development, which is one of few in Africa. I think there's only 2 of them, and it uses electricity. So it had to be a dedicated electricity in terms of a certain voltage, a specific frequency, and that. So it's difficult for us to get such a dedicated power source which does not have any. Because even when the power is there, sometimes it fluctuates. But if you are a household user, you will not know that the power is actually fluctuating. But when you're an industrial user, your equipment will actually stop. So we are actually going to be part of those people who will be looking for an external source that can give us a power that does not fluctuate, power that is guaranteed, because you know that per day, for example, this is the amount of production that you need, and this is the amount of power that you need. So I would say yes, for small producers who are not very technical, yes, you don't expect to have power all the time. But there are some producers now, and some consumers who now say we are willing to pay an extra tariff for us to have an immediate power. And I think Zesta is already working with such industries also. And that's why I think they are now creating this issue where some industrial users will be paying in US dollars so that they can be able to guarantee the level of power that they need.
All right, thank you for the question. So which issues give rise to the most disputes in the energy sector?
All right, that's a good question. So I think the energy sector, we have got so many stages of energy. Because energy is almost like minerals, where we actually do exploration. You start even exploring for energy, even if it's solar. You start with a map, you start with your satellites, you do exploration and things like that. So that's a different stage. You've got some environmental stages where you are looking at what is the environmental impact and things like that. The usage of water, what are my rights as far as use of water is concerned, the usage of land, what are my rights for usage of land. So there is so many moving parts as far as energy is concerned. But as far as the issues are concerned, there's a different between the developed world, obviously, and also developing countries. In the developed world, for example, the issue usually is about tariffs. Because the tariffs in the developed world, they change each and every day. They are floating tariffs. For example, your tariffs during summer are different from during winter. During winter, people are using a lot of power for heating, so they can go up even twice, even 3 times. Like when you look at what's going on now in Europe right now, power has just gone up. Then in Africa, it's like what my colleague just pointed out, the question of availability, the question of failure or of equipment, failure of generators, which then gives rise to those issues. So here it's more of issues that are more of generational issues, generational power, transmission of power, availability of power. Then in the developed world, it's more about pricing. Yes.
And approximately what proportion of the disputes you encounter become the subject of dispute resolution?
I would say, because the energy sector in Zimbabwe, it is just now starting to get privatized. Government is the biggest player, which means so there's not much dispute as far as the projects that are being run by the government are concerned, but there are private projects that are coming in, and most of them people are just dealing with their issues privately. Of course, we have seen some calls that are going on. I don't have to mention them. But yes, we have had a few. And right now, I think one of the biggest problems is that when most people started their projects, Zimbabwe was using US dollars. And the tariffs, the were being paid in US dollars. But now when the tariffs started being paid in dollars, it now became difficult where the producer and the developer wants to be paid by ZESA, that it is in US dollars, but as the consumer we are paying in RTGS. So I think that's one of the issues that has really happened now, and some of those issues have gone for arbitration.
All right, and what are some of the remedies that are generally awarded, if there's any, in terms of cases that are looking in courts?
I think right now, some of the remedies that have been sought actually goes all the way to termination of contracts. But I've seen that developers are more willing to just focus on specific performance. But sometimes you find out that if someone is not able to perform for a long period of time, and they are still asking for specific performance, then sometimes you see that it will no longer be an effective remedy.
All right, thank you. I think maybe for James, there was a question that I had in mind, which can maybe also attend to. What factors most likely influence the choice of dispute, of a dispute resolution method?
That's another good question. Money, cost, and time.
All right.
Time means money. So arbitration is beginning to get more expensive. Like in South Africa and the United Kingdom, arbitration is actually, people run away from it. So because it's getting expensive. The claimant and respondent, not only do they hire lawyers, they hire advocates and counsel, and the costs go up. So that's why adjudication has become more common. So at the moment, in South Africa and the Kingdom, adjudication is the preferred ADR. It's a quick fix, but it's done throughout the contract. A lot of arbitrations happen at the end of a contract, or the contract's completed and they're arguing with the final account. I don't know, but adjudication seems to be the preferred way of settling disputes in the construction industry at the moment. It's not quite getting in Zimbabwe, but I think it will.
All right, and I think maybe just for the flow, the last question that I might have is, are there likely to be any significant developments in the near future that will impact upon disputes in at the energy or the construction sector?
I like to say one thing I mentioned earlier, and Arnold touched on it. It's the I'm involved with 3 arbitrations at the moment, all on the regs, statutory instrument, 33421, and the arguments were contracts are signed in US dollars. And not only does the respondent want to pay in Zimbabwe is only paid a rate of 1-to-1. And that needs to be resolved. And I feel that I feel my heart goes out to the power statements. You have to deal with this. They're signing these contracts in US dollars. And the other side wants to pay in local at a 1-to-1. And that's caused a lot of problems. And the Supreme Court has ruled on it. I don't want to comment on the Supreme Court, but that needs to be the arbitration community here needs to be. I take a view on it. Is that how can we help the parties in events where legislation has interrupted the contract, the financing of the contract in some way? I don't know what the answer is, but it is becoming a major problem.
All right.
No, I totally agree, because obviously whenever there's a major change in the economy, a lot of issues arise in business, because when people build their financial models, financing models, there's a few currency that's in place, and there are so many agreements that we have done, and some of these agreements we have meant, for example, to finance these projects over a period of 20 years. Because an energy project can actually have a financing of even 50 years. When we look at in America, for example, wind farm can have a financing of 50 years. Most of them is 35 years. So it's in Africa it's difficult to have an economy that can be stable for so many years. So I think that's also one of the reasons why it has been difficult to even get the funding for some of those projects. But obviously, what now has to be done is that the government has to bring a certain guarantee that it has to guarantee some of those projects. Or you can have an external guarantee, maybe the World Bank can now, through one of its arms, be able to guarantee those projects. Or African Development Bank can be able to guarantee. Otherwise, for you to just have a local financier guaranteeing that project, it's difficult. It's not easy.
All right, thank you for the responses. I think Sarah is raising her hand.
Yes, thank you very much, Rutendo. And thank you, Arnold, for your presentation. It has been very insightful and very helpful, just as good as what we heard from Leon and James, apart from the jokes about lawyers. But we always say people appreciate the value of lawyers when they need our services. So we will take that in our stride.
Absolutely. No, on that point, let me say something, Sarah. I'm actually nervous in arbitrations where there's no lawyers. So lawyers bring the issues, they focus the issues from the clients very quickly. So I'm all for having lawyers in arbitration. And in fact, if I'm in an arbitration and one party has a lawyer, I almost insist the other party gets a lawyer. It's actually, the lawyers are a valuable part of arbitration, valuable.
All right, thank you, James, for that vote of confidence in our services. But I was going to ask Arnold and James to comment on Arnold's point about the early neutral evaluation. I don't know to what extent the early neutral evaluation equates to the adjudication process that that James has spoken about earlier, where he said it's a rapid way of resolving disputes without involving lawyers. And then we have Arnold saying that in the energy sector, they are trying to encourage parties to energy disputes to have early neutral evaluation, which is an assessment as to what's the prospects of any litigation or any formal judicial process would be with regards to resolving any disputes. And then my second question was going to ask, Arnold, you spoke about having an arbitral panel of 3 persons. in the energy sector, is that the norm, that the arbitral panel is 3 rather than 1 arbitrator? And is there any particular reason for that? Because obviously, when business people are looking at the costs of the arbitral panel, normally people want to try and minimize the cost or even of arbitration. So is there any particular advantage to people having an arbitral panel of 3? And then my last question would be with regard to the issue of consequential damages. I know that in Zimbabwe, we are generally not a litigious country when it comes to our national utility, ZESA or ZETDC. I think many people have actually suffered serious prejudice as a result of either the non-supply of electricity or the failure of ZETDC to have a load shedding program which they actually implement or which they abide by. And so with respect to the new independent power producers which are coming in, are you finding that there is now a more aggressive attitude by customers to say, if you are going to supply power to me and I'm paying you at commercial rates, which are probably more expensive than what ZESA as the national utility is charging us, is there a stronger desire to hold independent power producers to the contract to say, if you don't supply the energy, there is going to be a claim for consequential damages, or there's some method of calculation as to what the damage to the particular customer will be? So those are my 3 questions.
Well, going back to, I think, what you termed early neutral evaluation. The trouble is that mediation, adjudication, arbitration, it's private and confidential. It's only when it gets to the High Court and the Supreme Court that it's in the public realm. And I'm reading court cases all the time, and the courts do a good job. But what you've got me thinking, sir, what I'm going to do, I'm actually going to contact the JCT in London. I'm also going to contact the JBCC in Johannesburg. See if I can get statistics on without any private on how our adjudication works, because it is private, but they must have some information, because it's a very good question. At the moment, I don't know. I mean, even what I do know is that the amount of arbitrations ending up in the High Court is increasing year by year. When I started arbitration 25 years ago, there were 1 or 2. Now it's 1 or 2 a month. But it's about, I don't know. I need to get information on how adjudication actually works in terms of percentages. How many disputes are, because often the centres don't know. The people who publish these contracts aren't aware of the outcome. But I'll try. I think it's worth trying. I'll try and get the information for you.
All right, so with respect to the 3-member panel, most of the time when you're drafting a very complex contract, then like an energy contract, let's say, for example, I'll give an example of contracts, from the United States, a wind contract, for example, wind development contract, even a PV solar project, it's a huge project. So what they do is that on that dispute resolution clause, they will then be able to say, for example, if a dispute is below 500, the value is below $500 million, it's okay, you can have 1 arbitrator. But if the dispute is then above $500 million United States dollars, then you make sure that you have got a 3-member panel. So now if you are now in this Zimbabwean context, this is when parties now need to negotiate and say what level of dispute do you think we can just have one arbitrator be able to attain it, and what level of dispute do you think we are now going to have 3 arbitrators to entertain it. Then the other issue also is that let's say in Zimbabwe, but most of the agreements I'm seeing that Chinese companies are being involved, sometimes the European companies being involved, a foreign investor is being involved. So sometimes because this is like a joint venture, you know, these guys will then say, you know what, I think it's best for us, you know, to be able to bring our own, to appoint our own arbitrator, and then let the other party appoint its own arbitrator. Because, you know, some people can even choose to appoint an arbitrator from outside Zimbabwe. They can actually say that's what they want, or even to arbitrate outside Zimbabwe. Because now the trends that I'm seeing, most foreign companies coming to do projects in Zimbabwe, most of them are now refusing to do dispute resolution here in Zimbabwe. And they've now become a huge headache. And some are asking to go to South Africa, things like that. So personally, it's where I work, where I've now been able to go around it is to just say, you know what, we can have arbitration here in Zimbabwe, but if you want to use English law, that's fine, but the arbitration will be done here. Because we are not going to finance arbitration in Europe and China. The cost is just too much. It's better if they want the English arbitrator to come into Zimbabwe, they can come in and reach here, because at least the cost will become more manageable. Then, so the issue of the member panel, it doesn't have to be, if it's a small dispute for a small amount, definitely let one arbitrator deal with it. But if it's a huge amount involved and it's a multiple parties from different jurisdictions, especially when it comes to a matter where it trusts, the parties are not really trusting each other. That's where you see that, you know, 3 arbitrators actually. But if there is some level of trust, if there's continuation of business, then it's easy for you to have one arbitrator. But if the contract is terminated, then most of the time you are going to have each party have its own arbitrator. Then regarding the issue of consequential damages, obviously for that it's not really fun. I'm not going to do it. Yes, and even if we were going to try, that would probably bankrupt the fiscal in a single day. Yeah. But as far as the independent property research, it is very possible. But now, when the reason why people draft contracts is because they want to at least control what's going to happen. When you do allocation of risk, you want this business relationship to be at least determinable, to know what's going to happen in the future. So the problem with consequential damages is that you lose control of what can happen in the future. And you know, that's why sometimes people put this clause for the limitation of damages, say maybe damages are limited to 100% of value of the contract, or they are limited to the annual value of the contract, to the monthly value of the contract, or things like that. But in practice, what I've seen now being done most of the time is to have penalties, for example, that if you fail to deliver the power for certain hours, this is the level of penalty that you are going to get. So parties will agree on the penalty, and that penalty can then be calculated and be added, subtracted maybe from the amount that is due, whether it's a monthly amount or an annual amount. So penalties are usually what I use, because consequential damages, this now opens the door where you don't even know it ends. So it's not a good thing for contracts, because contracts are supposed to limit the relationship between the parties and produce a framework where nothing can happen outside that framework. And the only thing that should be happening outside the framework is a force majeure event.
May I say something, sir? On 3 arbitrators, Arnold's right. It must be a fairly substantial amount of money to be able to afford 3 arbitrators. What the Act says, under Article 11, the Act says that if the parties can't agree on the number of arbitrators, there shall be 3 arbitrators. Each party is allowed to pick their own arbitrator. It's in the Act, and then those 2 arbitrators choose the 3rd arbitrator. Okay, and Arnold's right. You know, it's a complicated a large sum of money, multi-millions of dollars. Very technical. It could be beneficial to the parties to have arbitrators with different expertise, and the Act allows for other nations to be the arbitrators. So the arbitrator can be appointed that's familiar with the claimant, and another arbitrator is familiar with the respondent, and a third one, you might have some other skill that'll help the arbitration. Thank you.
All right, I hope Sarah, you're unmuted.
Yes, I am. Thank you very much.
All right, okay. So I guess this brings us to the end of our program. I would like to formally ask Ms. Sarah Moyo to give us a vote of thanks, and then I guess we will close the program.
Oh, thank you, Rutendo. Is that not supposed to be Dr. Tambudzai?
Sorry, ma'am, Dr. Tambudzai didn't want to join the meeting.
All right. No, thank you very much. All right. So I think it just takes for me as chair of ZNCC's ADR and Legal Committee to thank the speakers for today's meeting. It has been a very, very interesting presentation. Thank you very much to our speakers for taking time from their busy schedules to come and speak to our membership and our audience, especially taking into account that you are doing this during business hours. In fact, initially we were going to have the meeting a little longer, but two of our speakers were not able to attend because of the business hours. And then to our audience who have joined this meeting, this virtual meeting, thank you very much for your participation. I'm sure you learned a lot about ADR and its application in the business environment. We hope to have further sessions in the new year with respect to ADR and its application in other sectors of the economy. And last but not least, I would also like to thank the Secretariat of ZNCC for putting out the invitation for this meeting and for hosting this virtual meeting. And last but not least, also to our moderator, Ms. Rutendo Mugaza, who is a member of the ZNCC ADR subcommittee. Rutendo, thank you very much for moderating this session. Thank you very much.
All right, thank you.
Thank you.
Yeah, have a good day, everyone. Thank you very much for attending.
Thank you. Very good.
Thank you. Bye.
Thank you.